I think we should go ahead and get started. Welcome everybody to our Wednesday Zoom and Learn. Glad you can make it. We're excited to have you with us. And today we are covering everything to do with cancellations. The why you don't want to do them, the why you have to do them, and everything in between. And Mary Jane's going to bless us with her knowledge and fill everybody in with the do's and don'ts. And we hope that you will ask questions as they arise as well, because we want this to be as interactive as possible. So I guess without further ado, Mary Jane.
Hey everybody. So I'm Mary Jane from Granite Escrow. I was hired a couple months ago now to bring a broker level of training and support to a COVID real estate world and try to make some of the distance between what we do and what you do smaller. Today, I want to talk about cancel escrows. By the way, we did intend to have the CRM LS girl. I no sooner got done pitching her last week than she notified me she had double booked, and we're going to push her into October. So I apologize for the miscue on that one. This is one of my favorite classes to teach because it's either cancellations are either done without enthusiasm and poorly, or over enthusiastically and angrily and potentially wrong. So I would like to I'd like to bring up the cancellation form itself.
Yep.
If that's okay. Thank you so much for always backing me up on my IT, making me look good. So most of you have seen this form, unfortunately, and most of us are aware that it is a two-part form. It accomplishes both the goals that escrow needs to release the deposit. It sets who canceled and why, and then it sets below who's getting the deposit or if it's going to be held for a dispute. The top half of the form, you'll notice, only has one party's signature. It does not require two parties to cancel an escrow. If it does, that doesn't mean you did it correctly, but it does not require two parties to cancel an escrow. A single party, if they're contractually in the right place, can single-handedly cancel an escrow, like a buyer when he's done. He hasn't removed his contingencies. We discussed this last week as well, that for the first 17 days of the contract specifically, and practically until you have released all your contingencies, the buyer does not even need a reason to excuse himself from the escrow. He has no obligation to explain himself. He can just not want to. The best way for you to protect yourself from opening up a door that you don't want to open, and we discussed this last week, is without a reason that's in the contract, you are opening your door to breach of contract. So the school of thought, many of you know this already, and if you don't, is to the best of your ability, anytime you are writing a cancellation and your side of the transaction is cancelable, and we'll talk about seller rights a little bit here, but as a buyer, you want to go with paragraph 14 every time. You have a right, you don't have to explain why, you do not owe anyone an explanation, and paragraph 14 is a viable, clean option to exit a transaction, no matter how we got here or who's mad at who. So at the top of paragraph 1, directly below the number 2 there, you'll see that there's a choice. Seller or buyer, or both buyer and seller, are canceling the transaction. Regardless if both people, even if you were to mark the box at both people there, only one party is going to be signing the cancellation. So at that point, you are the drawing party, and very often the person who drew the cancellation, if they are not the party who should be canceling, could invalidate that cancellation. So it's very important that there are times when you will call me and I will say that we will be talking about a particular situation where the seller is forcing your hand on cancellation, but you don't really want to cancel. It is in your best interest to hold on and wait for the other party to write the cancellation. When I'm a broker and I am deep in this with you personally, I will literally instruct you not to write the cancellation, that you are to wait for the other side to cancel, because we do not want to be the canceling party. So even if you use both the buyer and the seller agree, only one party is actually drawing and canceling that contract. And so very often, in 90% of the time, it's going to be the buyer, and paragraph 14 is going to be the paragraph you want to go for. The next choice on B gives the after you've given a notice of reform and they didn't release the contingency, that would be the box where a seller is enforcing a notice of reform and is actually canceling the contract. The seller to perform, there's very little on a seller to perform, all contractual stuff, no contingencies, just contractual stuff. And so they only have one single contingency they can remove, which is to locate or close on a replacement property. Otherwise, they are, it's a contractual action. They owe you HOA docs, or they owe you a roof cert or a septic or a survey or something like that. This other one is the party has failed to close escrow after beginning a demand to close escrow, and it could be in either direction. Sellers, Tommy and I talked about last week. I forget what the example was you gave Tommy last week about when a seller will drag his feet and not want to close. Okay.
Yeah, I mean,
think of it, it's okay. And then there's a box for other. Now this is the one that I see uninformed agents using all the time. Buyer hated property condition. Something else there. This is, and I gave an example last week where somebody had used their box and had written in there trying to obtain sympathy that one of his family members was hospitalized and another one was having some sort of mental breakdown, and that they financially could not continue the transaction and take care of their family members. That's the one where I told you that I was able to go to small claims court and ask, not because he had removed his contingencies, but I asked for his deposit because he did not use an applicable reason to cancel the transaction, yet he served me a cancellation. Now, even though I didn't agree with the cancellation and I'd still be going after his deposit, once the cancellation is served, it is a canceled transaction. It can be brought back to life, and we've done this way down the road in the cases of short sales, and we've done it 10 minutes after everybody's done arguing. It can be brought to life, but one of the things I try to tell people when they're working on notice of reforms, and partially why I wanted to teach cancellation right behind notice of reforms, is that you positively have to be paying attention when you're doing a cancellation. It is not a it's not an escape. You're not for your agency duties, even though you're not getting paid, you're not released from trying to get the deposit, help them get the deposit back. You're not released from talking to them. Many younger agents will tell me that they are never going to speak to that person again, and they're not helping get back the deposit. And it's one of the tougher conversations where I have to speak like a parent and tell them that they will positively be helping me get the deposit back. So cancellations can, the person who writes the cancellation and the reason they give can backfire on you. So be very careful about when you are canceling. Let's see, I've got some notes here. So we've talked a little bit about who should cancel and for what reason. And we've also talked about who should wait and for what reason. And then I want to talk a little bit, before we get into the cancellation, I want to talk a little bit about how to avoid a cancellation. I think Tommy will agree with me, and most of the senior agents on the website as well will say that going dark is probably the #1 reason that you gotten a cancellation. You just positively disappeared. So one of the things I tell agents all the time, so they'll call me for my advice, and I just don't want to release this one thing, And so I'm not going to send them anything. And I said, the actual proper procedure is to remove what you can and send an extension for the other. And if nothing else, it gives them something to chew on, as opposed to just go completely dark on them and they don't know what's going on with you. I tried to be, was there a question? I try to be as specific as I possibly can when I'm telling a person why I'm held up for some reason. I quite specifically can't get a hold of the boss who needs to re-verify the income. I'm waiting for the IRS to send back the proof of the taxes. I'm waiting for one more pay stub. So when you call and ask for my advice and you tell me they're held up, the first question I want to know is why. And I need it to be very specific. It can't be, well, I don't know, they're having loan trouble. Okay, there are specifics to loans about what kind of trouble they're having. And in all of our experience, we're going to be able to decide whether that is a solvable in the time frame you have to give them problem, or if it's not. But going dark is never a good way to go.
Yeah, and it seems like a lot of times that's what happens, and it causes more issues than it needs to be, right? Communication is key to the transaction being as smooth as possible. And
when I was an escrow officer, if you were really melting down on me, I would tell you that I will call you every morning and every night. And that's what I do, because then I could work during the day trying to solve the problem. I'd call you in the morning and say, we're exactly where we left off, and here are my goals for today. And I will let you know by 2 o'clock or 3 o'clock or 5 o'clock exactly what's going on. If I have to keep that kind of communication up, it very often will save the transaction. And I don't just mean from the escrow perspective.
right. I mean, even say from a buyer's agent going dark, right, with the selling agent or with the listing agent, you know, a lot of times it's because things happen with the processing of that loan, or it's getting held up in underwriting or something like that. And unfortunately, as going dark makes it 10 times worse than it really has to be. If the communication was given to where, hey, we hit a snag with underwriting, here's what happened, or I'm not certain what happened yet, but I'm trying to get the answers and I'll keep you posted every step of the way, is definitely going to keep the conversation away from potential cancellation, right? Especially when you're down to day 21, 22, 23, et cetera, and you're asking for contingency removal and you're not getting it, but you're not getting an answer at all, right? And no answer is the worst answer.
And you're not sending over what you could have sent over. You had your inspection, you negotiated your repairs, the termite work's underway. There's no reason you can't give them a partial contingency removal.
Real quick before we go on, there is a comment or question in the comments that said, did you say that if the cancellation is delivered, whether signed by both parties or not, the transaction is canceled?
Period. So a seller will cancel after a notice of perform and go right back into an escrow with another person, and the agent will call me and go, he can't do that, I didn't agree. No, there's only one person who's canceling. Either party can cancel. Now, if they did a poor job of canceling, I can help you piece that apart and we can get back to it, and we'll serve notice performs and bring their broker in and get them involved and get us back where we're going. But it is only one person that's canceling, even if it's mutual, period, end of subject. Now, here's one that's very easy for you. I was helping with an escrow recently, and the buyer went to the inspection like day 2 and hated the property and immediately backed out. Because we had inspected over the weekend, we hadn't even opened escrow. The buyer only signed part 1, and there was no escrow open and there was no deposit on file. So I don't even need a seller signature at all. There's nothing. We're going to talk about what's on the bottom half of this form in just 1 second, but that transaction is canceled. So when they replied that the seller wasn't available to sign, we said, no problem. We've done what we needed to do and backed our buyer out of this transaction. So one party is canceling. Both parties are agreeing what's going to happen to the EMD, which is I'm going to move on to the.
Well, hold on, before you move on, let's clarify that statement real quick, because if the cancellation came from the seller, the seller still has to go through the process of leading up to cancellation, right?
Correct. Yep.
So there is documentation that needs to be done before this is a binding cancellation, and that is notice to perform, etc. As long as the documentation was done and then nothing moved forward from that, cancellation can be issued and it is considered canceled.
Even if you stayed in very high contact and you and the agents are best buddies,
Right.
the parties can just be done without your approval, per se. We can circle back to any question you guys have about any portion of this form, but let's take a look at paragraph 2 of this contract. So the 2 things you need to completely cancel. Let's talk about why Carr added this in the first place. So you get all canceled and the buyer wants his deposit back, and where do you think you went? And God help me, I'm an escrow officer and I'm speaking to you from Granite Escrow today, but in the food chain of life, transactions that are recording have to come before transactions that are canceling. So maybe at the end of the month, the escrow officer is not going to be able to write your cancellation the way you want it and help you negotiate with the other guy who's upset with you. And you are going to have to do the work so that you can get the check from the escrow company. If this is successfully done right and signed, meaning one party canceled and both parties agreed to the deposit, escrow does not need to write anything else to cancel that transaction and release the check. So the bottom half of this is to also cancel the escrow and to say what's going to happen to the deposit. There are 4 choices here. Seller authorizes the release of the deposit to the buyer, less fees. The buyer authorizes to the seller, less fees. The buyer and seller mutually agree and hold the deposit while we have a discussion about it. Or 4, I always think this is a fun question, a little fun test question for you here. What's missing here? Where's the one that says give my buyer back his deposit, 100%? There is specifically not one there for 2 reasons. There are occasionally services that have to be paid. Termite companies, maybe you've gone way deep and long with an escrow company, not mine because we were 100% cancel, no cancellation fees. But maybe you have gone long and hard and there are going to be cancellation fees. Most of us have been in real estate long enough that we can call our Tommy or our me and we have a relationship and we're going to be able to get cancellation fees waived. But the reason that they're built in is because it needs to be factored in whether anybody is owed anything to cancel the transaction, starting with the escrow and perhaps the title company, but I can't remember ever seeing a cancellation fee from a title company. So you will have to add in number D, the EMD to be returned to the buyer without reduction or deduction. You don't need both those words. It's just they sound a lot alike and either one's fine. So EMD to be returned to the buyer without reductions and without deductions. This is where we most often have the next problem I want to talk to you, which is conflicting instructions. So occasionally both parties want to cancel, or both parties or a seller will write for the buyer that he's the canceling party, which you cannot do because, and then sign it at the top. The buyer canceled, but the seller signed it. That's not what that says at the top. And then at the bottom, one person wrote, even if they did the top right, one person wrote, give me the deposit, and the other person wrote, give me the deposit. Again, you're keeping your escrow officer from having to write 2 instructions, because when both agents call in and say, write me a cancellation that says this, we're required to do that. We know where it's heading. It's heading to the legal term called conflicting instructions. When the instructions do not match, we cannot perform on them. So sometimes the only way I can get agents to understand that they are giving conflicting instructions and that simply writing a cancellation the way you want it to look and the way you want the deposit to go is going to be somehow enforceable. It's not. It is truly only causing conflicting instructions, and escrow is required to come to a full stop and no deposit will be released. In fact, I was just talking to a very well-known team this morning because when several people lost their jobs and different things happened during the COVID, even though they triggered the COVID rule, we haven't been back in court yet, and we have not had any successful escape in small claims court over COVID rules. We just haven't had it yet. So the seller's just saying flat out, no, no, I don't care if we were far enough along, and the fact that their agent didn't explain to them that the contingencies weren't released. But sometimes the seller or buyer will just plant their feet, and no amount of advice or calm talking will get them to do anything but take it to small claims court. So during this particular team that I take care of, during the COVID, from March to about June, they had about 8 transactions cancel, and they have 8 deposits stacked up. I have various levels of understanding through those people. Some people understand that, yeah, nothing's going to happen to when you get back in small claims court. Other people are demanding to negotiate again. So cancellations can sit and sit. One of my favorite things to tell buyers specifically, and if you're managing their expectations, that as an agent, you will make the speech when they turn in their deposit. If the deal were to cancel for any reason, and you have certain rights, including your 17 days, and you don't need a reason, it may take a little while to get your deposit back if the other party won't agree, but it is going nowhere. That deposit is staying in escrow. There's only 2 ways legally to release a deposit from escrow. Mutual agreement, means that everybody signed what's going to happen, or active law, and there are no other ways to release. Now, a few years ago, semi-recently, CAR added to our contracts the demand to release the deposit in the contract. And if no one answers in 10 days, that escrow company can now take it upon themselves to release that deposit. This was originally designed for somebody who was REO sellers who disappear and won't sign for the deposit. You can't get them on the phone. You can't even find that asset manager anymore. Somebody leaves the country. It was originally designed for where no one's competing for it, but no one's available to sign for one side or the other. So that's who it was originally designed for. The problem is both the big escrow companies, meaning the DBO license companies and the title companies, they don't need this risk, because they're going to get named in that matter when it finally makes it. And if it's a big deposit, it's going to be outside of small claims. So almost nobody will honor the demand to release the deposit, even though it is a contractual they have internal risk management procedures that will not allow them to. $1,000 is too little to bother with, and $1 million is too much to bother with, and something in between is one or the other. So, so when you cause conflicting instructions, so when I get a cancellation poorly written, and you show it to me, we will write it the way it was supposed to be and send it back, but I will warn you right from that moment that we're causing conflicting instructions. We can't perform on the one they sent us because it's not right, or it's not factoring in the legitimate claims of the party, or it is a conflicting instruction and nobody can act on it. Anyway. The bottom of the bottom paragraph says that if you check A or B and you authorize the release of the deposit, you're putting to bed any further claims, which circle back to the liquidated damages in the first place. We talked about this in another class, but when a person initials or does not initial the liquidated damages, it is not agreeing to liquidated damages, meaning that if a seller fails to negotiate, he's not saying that, if he fails to initial it, or a buyer fails to initial it, you're not saying that you don't agree to liquidated damages. What you're not agreeing to is that the EMD is enough to put away those claims. So if you read the liquidated damages clause, it says that it is agreed in advance that the amount of the deposit is sufficient to cover all seller's losses at any point in this cancellation. And the reason why you will find the more informed seller not initialing them, or an attorney or something, is because this gives them a right to exceed up to 3% the amount of the deposit. So even on certain types of transactions, the deposit, if that box is not checked and initialed by all parties and tidied up during negotiations, they will not have, they will not be limited to the EMD amount. So lots of people think that the seller missed it and lucky me, he's not going to get my deposit. That's not what it means. What it means is he now has an opportunity to go for more than was in the deposit. So this is very popular in million plus transactions. Anybody with an attorney, a CPA, anybody who has any real understanding of liquidated damages is not initialing it. Please remember also that the 3% cap only applies to owner-occupied transactions. It does not apply to investors. So it doesn't, in any sort of investor property, it does not cap at 3%. If it is not an owner-occupied transaction and it is an investor transaction, they can be liquidated for whatever amount they put on page 1 or agreed to later in the transaction. So one of the things I wanted to say about noticeable forms too is that some tech people tell me, well, I got my notice for form and we're not going to be able to do it. You know, we're going to miss the deadline and I'm just going to take my chances. And I say, that's totally up to you. But at any time after that moment, the cancellation could come in. So, and then it is a different thing. You have to, it is not a negotiation ploy to send a cancellation. You've actually canceled. And therefore, you're going to have to uncancel, even if you did use it as a negotiation ploy. It does cancel the transaction. So I hope that answered the question that was asked. Although this seems like a very simple subject, and I told you that I try to break them up. I try to do something a little lighter one week and a little more serious the next week. This was the lighter version, but it's a very important thing to know how to use this form to accomplish your goals. Either to completely cancel and get the deposit where you want it to go, or to create a conflicting instruction. The proper way to uncancel, strictly an addendum. All parties agree that contract dated above, I'm sorry, there was a question. How to uncancel a transaction. An amendment saying that all parties regarding the contract named above, because we always have that little preamble in our car documents, have agreed to continue the transaction and the cancellation is now null and void. Usually at that point, it then also continues with some other terms. The deposit's going to be released. We've agreed to extend. The buyer will put another $5,000 in escrow. He's given up his repairs. He's not going to get a credit. There's usually something that goes along with that when you uncancel, but at the very least, you have to say you're uncanceled and you have to reset the closing date and any terms that you want to bring it back to life. But it is literally that, easy. Tommy, got any thoughts for me on this one? It's pretty simple today.
You know, honestly, I don't, which is not like me, but nothing, no questions from myself came up during all that.
I think that you guys are going to get off without me running off over time today.
Well, let's open it up too and see if anybody has any questions in regards to cancellations or the process leading up to cancellations, issuing a notice to perform, etc. And if so, you can feel free to just take your mic off mute and ask it, or put it in the chat, either or. Are we done with this cancellation contract form?
Another thing, I just had a thought myself, that once a seller cancels a transaction, if he has not settled the deposit with the buyer, he cannot close escrow traditionally in the same escrow company. So you mostly have to, you usually wind up moving your escrow somewhere else. did recently discover in my trading at Granite Escrow that we have our E&O company wrote around that. And if all parties say that they're going to set it aside for another argument, they are allowing us to close, but I need a waiver. And that's hard to get sometimes when somebody doesn't want to sign something for you in the first place. They definitely don't want to sign something in a second.
Daniela had a question. It said, notice to perform can be accompanied with the cancellation. She's asking you if it can be.
I'm trying to think of, my immediate instinct is no, because you have to wait out the 2 days. And by the way, I did a little research on that 6 months ago or so. That literally in the contract book, and then I called Carr about it, it says 2 days. It doesn't say 48 hours. It doesn't say midnight on the second day. It says 2 days. So if you served it at 3 o'clock in the afternoon, it's 2 days and 3 o'clock in the afternoon. So there is no midnight or 5 p.m. or
close the business. Right.
We all know that if they haven't closed by 5 o'clock on Friday, they're not closing Saturday because they can't there's no recording. So at that point, but even then you owe them the time. And during that time, they may come up with a solution. They may agree to release their deposit. They may offer more. They may back off their repairs. They may offer a term that brings you back. But no, you can't serve the cancellation at the same time. You serve the.
Are you able to stipulate in the notice to perform? Obviously, you're issuing the notice to perform for specific reasons, right? Mm-hmm. And can you stipulate in there that if those reasons aren't met, a cancellation will be a following?
I usually would put something on my cover letter to you. Tommy, hated to send you this because you haven't gone dark on me. You've been a great guy to work with. However, my seller is adamant. Monday morning, when it expires, you may expect the cancellation without further ado. So don't make me have to. I'm not going to call you again on Monday and tell you. But that doesn't mean I couldn't have said it pleasantly to you. Hey, Tommy, no kidding. She's not going another inch.
Right.
Honestly.
And again, it reverts back to the communication amongst the agents, and any communication is better than no communication, right? You may not have the answers from one side or the other being that agent, but communication can still smooth the situation, right? Because the communication's happening. It's when you don't have the answers or you don't want to release the answers and you just say nothing that makes it 10 times worse of a situation. And then sometimes it's those conversations that are hard to have, right? And, but they're conversations that after you have them, you're glad you did because it makes the situation easier.
And please don't forget the rule that if all contingencies have been removed, you're now waiting out a 3-day demand to close escrow, and you can't shorten that either. So the later you get in the week, the more you're going to be including the Saturday, Sunday, and holiday rule. So if you served me on Thursday, my performance date was Saturday for a notice to perform and Sunday for a demand to close escrow. Plus I get Monday because we were all closed for Labor Day, and I get all day Tuesday. So if your seller wants to take another, in fact, sometimes I'll count that for my agent, and we're working that angle. We're positively knowing that we can't get canceled until Tuesday.
Tuesday, right?
Yeah. So, and by the way, I've said this before in my notice of performance class. If you're served an improper notice of perform, or they shorten the time frames or the dates, start over. You have to start over. You don't get to, if you took the time to do a notice of perform and you shortened it to 1 day without the contract matching that you did in negotiations, it's worthless.
And if you're the agent getting that notice to perform and it says 1 day, you probably don't want to bring that to anybody's attention. You wait it out until it's brought up to your attention and you say it wasn't issued properly.
Yeah, I'm going to, or maybe I'm going to have my broker tell your broker.
Right.
Oh, I hated to tell him, but could you explain to him? Because he's not going to take it well from me either. He's going to be, because the people who cross it out are almost always ticked off. So they become harder to communicate with.
Correct. That brings me to one other thing. When you do get a document that was filled out from another agent or what have you, and it's wrong, don't alter that document. That's not your document to alter, right? That's the bigger no-no.
Yeah, redraw and do it right, and or send it back and ask for the corrections to be made. Like I said, motivation goes, food chain goes way down, you know, especially right now when you guys are all out showing, you know, all weekend to write 18 offers that nothing happens on.
Right.
It's frustrating to go back and have to fix the form to get your client in a position to do what you want to.
You know, and a lot of times, I mean, you're doing transactions with agents you've never met now, more so than ever, because these, you know, crazy offers are coming in, and that's the one your client wants to accept. And it's tough because you're working with somebody you don't know, you've never met, you've never heard of them, you don't know how, you know, what kind of business they do, and all you can do is your research. But the caution flag is always there, but you have to give it a chance, right? And by giving it a chance, it's mutually, it goes both ways. You know, you try and take care of your side of the transaction, and you hope that they try and take care of theirs. And if they don't, you assist. You don't tell, you assist, right? Nobody likes to be told what to do. Sometimes they just need help because they don't have the help. So take that in consideration is, you know, first assist, be the helpful hand, and play the good guy card first before the bad guy card. All right. Any other questions? We're coming right up on that 40-minute mark, which is perfect. Do we know what our topic's going to be next week? I can't remember when you said we moved.
I thought I was going to be doing cancellations next
Right.
week. I thought I had a CRMLS girl. I honestly could grab my book and see what everybody thinks. Hold on.
I couldn't remember if the one that we were supposed to do today got moved to next week or if that's next month.
October 14th. Yeah.
Yeah, okay, it got moved to next month. All right.
There's a class I teach called Unnegotiated Matters. I'm just giving you guys some choices here. So occasionally a person will call me back. A good example for this is walkthroughs where they didn't negotiate grandma chandelier, or it just didn't come up until we got there. And now everybody wants to lean back on the contract, and there are things in a transaction that are just flat out unnegotiated matters, and they have to be renegotiated. And we can talk about how those are done. Love to talk to you about requests for repairs sometimes. I think a lot of
You know what? Why don't we do that next week?
I've got lease options, which once you know how to do one, any real estate person who doesn't own a house personally and doesn't know how to do a lease option should call me, because they're completely viable way to do business. And the reason we don't do them here is because it's California and you can sell your property. So in every other state, they're completely a viable way to get listings and to buy properties. This one's a long one and I'm just throwing it out there, but I've got a 4-part where I take the disclosures apart for you: statutory, contractual, required, and recommended. Compensation agreements. I also have a compensations agreement class, how to handle that FSBO, how to not take on additional duties when you're going to represent the seller, but he's going to pay. You're not going to represent him, but he's going to pay you. How to take care of those, how to do a one-party showing, things like that. I have the funnest class on commercial properties. If you ever want to do a commercial property, they're so much easier than you think they are. And assignments, assigning agreements. I think we did that. Did we do assignments at some point way at the beginning? I can't remember. But
No.
so those
I like the disclosure one, because a lot of questions always arise with disclosures from all parties. I like the lease option ones because I get asked about lease options at least a couple times a month.
In that class, I not only explained the concepts, but I give you a one-page worksheet that has what I call the secret math. So once you know all the answers to these questions, you can negotiate any part of that transaction. It's not knowing what you don't know or not having all the answers so that you can negotiate the transaction between all the parties. I have a great speaker that comes on for that too, that backs me up about the legalities. Most people think in lease options that the mortgage can positively be accelerated upon transfer, but lease options and AITDs, I'm sorry, there's very strict rules about accelerating a mortgage. And when I tell them to you, I will honestly be giving you the keys to the castle, because that is the biggest fear of transferring property with a loan in place, is that it's going to accelerate the mortgage.
Yeah, I mean, I'm personally good with lease options or disclosures next week.
Disclosure.
There's a couple people that are piping in on the thing saying disclosures.
That
Some
would
are
take us
saying either or.
probably, that would probably take us right up to, because it's about the 14th, next week will be the week of the 14th. So that would take us right up to the lighter subject of the CRMLS. So if you guys want to do that, then it's statutories next week. This one is pretty basic, meaning you pretty much know those statutories, and they are aligned in your contract. And then the week after that, we do the contractual ones and how to get around those with flips and all that.
I think with disclosures, you don't think we can cover all disclosures in 1 week? No? Okay.
I can do statutory and contractual, and then do recommended and required together, and we can get it into 2 weeks.
Yeah, I think that'd be a good thing. Let's plan that for the next 2 weeks.
So statutory and contractual disclosures next week.
Yep.
And the week after that, recommended and required.
Perfect. Right.
I want to remind you again before I close that I was specifically hired for my license, my broker's license, and for the fact that I've always been a non-competing broker. I don't do deals. If I do 5 deals in a year, every single person has the same last name as me. So, because it's some sort of family transaction. So I don't sell. I'm not going to be competing with you, but I positively am a broker level solution for your transactions. So be sure to reach out for me. I will help.
Yes. She's always willing to answer the phone and help. So utilize that. As am I.
Thank you very much.
Yeah.
All right. Well, thank you guys for your time. And we look forward to seeing you same time, same place next week. It is always the same Zoom link, so that does not change. So if you don't see our posting in regards to the Zoom and Learn, you can always just log into that Zoom and you'll find us there. If you have any suggestions in regards to other trainings, please send them to Mary Jane or myself. We can be reached
Or
out.
you need them in other venues. You want to do it just for a particular class. You want to do it with your buyer because he needs a lesson in how you came to your decisions.
Let us know.
Yep, let us know.
All right, guys. Thank you very much. And we look forward to seeing you all next week.
Thank you.
Bye,
Bye, guys.